Good afternoon, everyone. I think as we are still waiting one more speaker to join with us in these discussions, I will start discussions by greeting all the speakers and all the participants that have been joining in this room. Good afternoon, everyone. Welcome to this session. My name is Miftah Fadli. I am a researcher in Institute for Policy Research and Advocacy, or ALSAM. ALSAM is a human rights NGO based in Jakarta, Indonesia, and I will be the moderator for this panel. In this today's panel discussion, we will cover topics related to the personal data protection standards at the regional level, learning from the national level, and development evolution. Before I give some backgrounds and objectives of this discussion, let me firstly read our code of conduct. Okay. As you can see in the screen, that we have some rules that we have to follow in order to follow these discussions. Please make sure your device has stable internet connections. I hope mine is also stable enough to moderate these discussions. And you can also use a complete form as your account name to join the meeting room. Please turn off and mute your microphone during the sessions. And I hope the participant do not leave or join repeatedly in order to make the other participants comfortable following the discussions. And if you are also comfortable, you can turn on your camera, but if you do not feel like turning your camera on, please do so. And the committee have the rights to expel the participants from the meeting room if he or she violating the rules and act inappropriate. Yeah, that's a glimpse of our participants, our speakers for these panels today. This panel is organized by Institute for Policy Research and Advocacy together with Southeast Asia IGF 2021 Committee. Our panel will discuss the development of personal data protection laws in several Asian countries, and challenges as well as opportunities that we have in realizing a stronger legislation for data protection. We all know that several Asian countries have already established their own personal data legislation quite long before the EU General Data Protection Regulation came into force. And as the EU GDPR affects the global landscape, the regulation is also shaping and reshaping the way many countries approach their personal data governance, including countries in the Asian regions. And today we are witnessing that the data processing is already too penetrative, yet some Asian countries still have no a comprehensive legislation in safeguarding their citizens' personal data. As you already know that there are many aspects left unregulated, and some human rights standards are still overlooked by the existing laws and regulations. On paper, there are only a few countries in Asia that have data privacy laws, including Malaysia, Singapore, Philippines, and Thailand. Even though we need to be aware of several aspects that is left behind, such as the status of the independency of the regulatory bodies, and to what extent that the existing laws have complied with minimum standards of the right to privacy as agreed by human rights standards. For your information, that this panel aims to explore a little bit more about the socio-political context that help shape the evolution of Asian's data protection standards. European countries have experienced different contexts compared to the Asian region that leads to the birth of general data protection regulation for European countries in the one hand, and in the other hand, Asian countries appear to choose a different regulatory model in both the development and implementation process. And in this panel discussion, we also we are going to look more detail into what aspects that influence these differences and what we can do to strengthen the regulation by incorporating human rights standards into the regulatory infrastructure, among other issues, of course, that might be coming up during this discussion. And before we jump into the presentations, I want to appreciate to all of our panelists for agreeing to speak in this discussion. Today, we are going to have 5 panelists to present their thoughts and perspectives for like 10 until 15 minutes each. Let me first introduce our speaker, Professor Abu Bakar Munir. How are you, Professor? Okay, Professor Munir is currently serving as adjunct professor from International Islamic University Malaysia. Is also a member of Personal Data Protection Appeal Board Malaysia and co-founder of Association for Data Protection Officers and Privacy Professionals in Indonesia. And as a renowned scholar on cyber law and data protection law, Professor Munir has authored several books on a range of issues around digital economy and cyber law and regulation, including the latest works chapter that is published by Hart Publishing UK that covers the use of cyber means to enforce unilateral coercive measures in international law. And our second panelist is Pak Samuel. I don't know if Pak Samuel is already here or... Okay, Pak Samuel is the Director General of Applications of Informatics from Indonesian Ministry of Communication and Informatics. He is also head of working team from a government representative for the Indonesian Personal Data Protection Bill. And before joining the ministry, Pak Semi held a position of Chief in Association of Indonesia Internet Provider. The third speaker is Dr. Ivy Paddu. How are you, Dr. Ivy? Dr. Ivy is a member of FMA's Board of Trustees. She is a physician, a lawyer, and health privacy advocate. And in 2016, she was appointed as a Deputy Commissioner at the National Privacy Commission in the Philippines. And currently, not currently, I think in the past, Dr. Ivy is a legal consultant for the National Telehealth Center for University of the Philippines, Manila, and the Department of Health Data Privacy Experts Group. And our next speaker is Ariane Jimenez. How are you, Ariane? Ariane is now a Facebook's Privacy and Public Policy Manager at Facebook Asia Pacific. And Ariane will share more about how private sectors play a role in relations to the development of personal data protection standards, especially in Southeast Asia. And the last speaker would be Mas Wahyudi Jafar. How are you, Mas Wahyudi? Mas Wahyudi is currently serving as the Executive Director of Institute for Policy Research and Advocacy, or ALSAM, and he has actively engaged in many occasions and many agenda to encourage the human rights standards in cyber law and cybersecurity, including his also leading in the process of the formulations of bill, personal data protection bill around among the civil societies in Indonesia. Before we dive in, this discussion is interactive. So for the participant, please use the chat box to drop a question or comments. And I also want to remind all of you that we provide an English-Indonesian interpreter. So please use the feature that is available in your Zoom. To begin with, I want to invite Professor Munir to start our discussion by sharing the Malaysian experience in implementing data protection law, including how Malaysia is compared to other countries, and how, in the broad sense, how the ASEAN regions is compared to other regions, and what kind of challenges and opportunities that we have to develop the ideal standards in the ASEAN regions. To Professor Abu Bakar, the screen is yours.
Thank you very much, Fadli. Bismillahirrahmanirrahim. Assalamualaikum and very good afternoon. I do not have any PowerPoint presentation to make because it's a bit too short. So what I'll do is that I'll talk about, I'll give some backgrounds because I think everyone here is familiar with this area of data protections, and I'll go into Malaysia. As we know that the ASEAN Human Rights Declaration provides for the right to privacy in Article 1. As we know that ASEAN has enacted ASEAN Framework on Personal Data Protection in 2016. So, and then we also know that ASEAN has come up with the ASEAN Framework on Digital Governance. And the most recent one is the ASEAN Model Contract Clauses for Cross-Border Data Transfer, which was issued in January this year. So it shows, I mean, it seems that ASEAN is very serious about this issue of, trying to come up with rules and regulations concerning data protection, especially among ASEAN member countries. And I think we know that by end of the year, ASEAN is supposed to come up with ASEAN certification for cross-border data flows, and as I said, to be finalized by end of the year. So as far as countries in ASEAN concerned, as mentioned, Malaysia was the first in ASEAN to have a comprehensive law on data protection, followed by Singapore, and then followed by the Philippines, and recently Thailand. And Thailand was supposed to implement the law of PDPA, or Personal Data Protection Act, last year, but it was delayed or was postponed due to the pandemic. So what I'll do next is to look at Malaysia. As far as Malaysia is concerned, so Malaysia enacted the law in 2010, but the implementation was done in 2013, I think 3 years after the act was enacted. So the reason being to provide some room or some time for companies and organizations to prepare towards compliance with the Act when it was enacted in 2010. Yeah. So to implement and to enforce the PDPA or Personal Data Protection Act, of course, we have to have supplementary regulations or rules, and for that, Malaysia has issued, or the regulator rather in Malaysia has issued a number of regulations, such as registration of data users, classes of data users, class of data users, Regulation 2013, and standards, PDP standard in 2015. Then several codes of practice have been developed, has been approved and developed by the regulator in Malaysia as well. Okay. So in terms of what have been done, as far as enforcement and implementation is concerned. So there was a report issued by the regulator saying that they have received thousands and thousands of issues concerning data protection. Then there were 140 complaints in 2013, and 82 cases followed up by the commissioner, and then they done inspections as well, inspections on system which is allowable in the PDP, in the Act, yeah? And a few cases have been brought to court because in Malaysia, there is no provision allowing regulator to impose penalty. There is no provision allowing individual to take legal actions. The only remedy available under the law of Malaysia is that criminal sanction. And so far, I think 5 or 6 cases which have been brought to court, and mostly, in fact, most of the cases, or all of them, I mean, the punishment is a fine of 10,000 ringgit Malaysia. Yeah. So the law was passed a decade ago, 11 years ago, or So I'm not sure whether this is a good record of implementation, but I can say that there are a number of challenges faced by the regulator in enforcing the law in Malaysia. First is, of course, about the awareness of the general public about this issue of data protection. Secondly, it's about the commitment of organizations, and also about whether they are able to inculcate data protection culture in organizations. The third challenge is, of course, some gaps in the law. Because as we know, the law in Malaysia does not apply to public sector or government entities. That is also the position in Singapore. Yeah, and I think the biggest challenge is, of course, the capacity of the regulator to enforce the Act. So I just want to give some figures about public awareness in Malaysia, generally on this issue of privacy and data protections. There was a report recently issued by Malaysia's Communications and Multimedia Commission. Of course, it's a very broad research or publication called Internet Users Survey 2020. So I think the findings of the survey is very, very interesting. One, according to the report, 30.6% respondents shared their personal information online. 30.6%. 80.3% shared their real name online. 76.7% internet users shared photos of themselves online in 2020 compared to 68.8% in 2016. So the other facts and figures given in the report is that 65.2% of the respondents shared their date of birth to people online. So based on this, I think the awareness is not that, it's still not acceptable in terms of, the willingness to share personal information online and the willingness to basically share other informations online, according to this report. So perhaps I can touch a bit about the position in Singapore, because I'm doing research, I've done research on the issue in relations to other ASEAN countries as well. As I mentioned, in Singapore, the PDPA Singapore does not apply to public sector as well, because there is a separate regime for that. But in Singapore, the PDPA allows regulators to impose financial penalty. So, in this aspect, I must say that there have been hundreds of cases where fine has been imposed against companies in Singapore. So, so in that sense, I think if I can say that the enforcement is more successful in Singapore as compared to Malaysia. And I know that in the Philippines, the regulator, the commissioner, Mr. Liboro, takes a different approach in enforcing the Data Privacy Act in the Philippines. And the approach is that more towards education rather than creating awareness, educations, and sanctions is the last resort. Yeah. So perhaps our friends from the Philippines can verify that, but based on my research and based on my conversation with the commissioner, that is the attitude adopted by the regulator in Singapore. A little bit about Thailand. Yeah, as I said, the law was supposed to be implemented last year, but it was postponed due to the pandemic. The argument by the government is that the organizations in Thailand are not ready because they are busy, and then because of the fact that the priority now is to combat the virus or COVID-19. And Mr. Fadel, the chairperson, mentioned about EU GDPR in his introductory remarks. I've done some research. In fact, I made a presentation last week about benchmarking EU GDPR with the ASEAN or Asia, rather, Asia countries' legislation. So there are some basically elements that derive from EU GDPR, especially the newcomers like Thailand. So in Thailand, there are basically some elements of GDPR in Thailand's or Thai's legislation, like data breach notifications, requirement of DPO, and a few other things. And I think Singapore has done the same thing in 2020. Amendment has been made to the PDPA Singapore, and what have been mentioned or been provided in the GDPR has been taken as a model. And I can mention a couple of things like data breach notification has been inserted in the Singapore PDPA, and then the right to data portability. Before this, there was no right, there is no provision on the right to data portability in the PDPA Singapore. But in 2020 amendment, this right to data portability has been inserted. So I think I stop there, Mr. Fadil. Perhaps we can continue our conversation after this. I just give the background.
Thank you, Prof. Munir, for giving us a little bit background and current developments on the Malaysian situations. I have actually two follow-up questions regarding the data privacy laws in Malaysia that you have mentioned before. Yes, you said that the personal data laws in Malaysia has been established 10 years earlier. And of course, we have witnessed 10 years of change. And there is also a lot of influence coming from another countries and another regions. And with that regards, what does Malaysian government do to address those changes and challenges that is coming up during the span of 10 years? That is the first question. And I think the second question is regarding to the ASEAN as the regions. What do you see as a distinctive differences between ASEAN regions compared to another regions, like in the United States? We have seen that the data privacy in the United States is quite weak because United States doesn't have any comprehensive privacy laws. And yes, what kind of differences between ASEAN with another regions? If you can tell us more about that, that matters, please.
Yeah, you are right. Malaysia has enacted the law in 2010, implemented in 2013. It's already a decade now. So to answer your question, what are the challenges? Yeah. So just like other countries, we have the benefits of GDPR as a benchmark now. So there was a proposal by the minister under the old government that Malaysia should amend the law or a law on this issue, and the minister specifically mentioned that some elements of GDPR will be considered, and I can tell you that some of the, and because of that, consultation paper has been issued recently. I think one year or 2 years ago. There were a number of proposals, but I'm not sure whether all the proposals will be accepted or some of it will be accepted by the government. But the insight is that a number of proposals in the consultation paper has been accepted to be discussed further. One is again on issue of data breach notification. Yeah, that is one. So it has been agreed in the sense that by the government that data breach notification is very, very important. Secondly, the issue of BPO. Certain organizations are required to appoint data protection officer. Yeah, and the bigger issue is, of course, whether or not we should do away with the exemption, the public sector. This is a very dicey, basically, issue as far as Malaysia is concerned. But hopefully, under the new government, they can listen perhaps to this issue of basically expanding the act to cover public organization as well. So that is about what has happened in Malaysia and what is going to happen with regards to the PDPA. And Fadil mentioned about US. We know very well that there is no comprehensive law at the federal level. in the US, but I think the trend is towards that. As we know, there were a number of attempts by the senators in the US to uh, uh, to convince the federal government, yeah, to enact a comprehensive law at the federal level. I think the latest initiative is by a senator recently, and they issued a bill. And interestingly, 10 years ago or 15 years ago, public sector in the US were very reluctant to have uh, data protection or privacy law in the US. But of late, after EU GDPR, I think EU GDPR has played a very, very important role in influencing basically the perceptions and the opinion of the business leaders, especially like companies like Facebook, Google, and other companies, because I think EU GDPR has been able to change the perception of the business leaders in the US. So if you look at the reports issued by FTC, for example, and the hearing held recently by FTC, where people like Zuckerberg, then the CEO of Google, gave their opinions. So to me, when I look at the report, it seems that they are agreed, yeah, to have for the US to have a comprehensive law at the federal level. So as it is now, there is no federal law there is no comprehensive law at the federal level. But I think my personal view is that it is just a matter of time, you know. Even FTC has been strongly, basically, arguing for comprehensive law to be enacted at the federal level. Another development in the US is about states. There are 3 states in the US that have enacted comprehensive law. One is California, second is Colorado, and third is Virginia. So, and more states are coming out with the comprehensive legislation on data protection in the US. So I think I'll stop there. To answer your question, regionally, yeah, regionally, whether or not we should have something like EU GDPR, we know for a fact that ASEAN framework on personal data protection is voluntary, it's not binding, but at least perhaps ASEAN framework is a good starting point. Yeah, I'll stop there, Mr. Fadil.
Okay, thank you, Prof. Munir. We can digging up more about these issues later in this in the Q&A sessions. I will be moving on to our second speaker. The second speaker is Pak Samuel Adriani Pangerapan. Pak Semi will discuss the direction and progress of the development of personal data protection law in Indonesia. To Pak Semi, the floor and the screen is yours.
Thank you, Fadi, for the time. Prof, how are you? Prof Abu Bakar, last time we met is 3 years ago or 4 years ago, when you were visiting Jakarta. Aryan, how are you? It's the last time I discussed with Aryan is when it's the celebration of 4th of July, and very nice discussion. And my friend, good friend also, Wahyudi. Hi, Wahyudi. It's a long time no see also. And also nice to meet you, Dr. Evie. It's be honest to be in the same panel with you. And I would like to have a screen share. I have a 4 slide to share with you regarding the Data Protection Authority. So on my presentation is in English, but allow me to present this presentation in Bahasa, but you can follow me on your Zoom and select the English mode. So we don't have any language difficulty on the understanding my presentation. So seperti kita ketahui bahwa data pribadi, undang-undang RUU data pribadi kita ini inspire-nya dari GDPR, dan ini sudah diserahkan ke DPR oleh Presiden tahun 2020. Itu dan ini sudah sedang dalam pembahasan. Nah, pembahasannya cukup panjang karena memang banyak daftar inventari masalah yang perlu dibahas bersama parlemen. Terakhir kita membahas tentang kenapa tadi presentasi saya hari ini adalah tentang Data Protection Authority-nya. Ini supaya kita bisa sharing apa sih sebenarnya perspektif pemerintah terkait hal ini. Jadi kalau kita bicara Data Protection Authority, tiap-tiap negara punya model dan model yang berbeda-beda. Singapura punya modelnya sendiri, Malaysia punya sendiri, Israel punya modelnya sendiri, Uruguay juga punya modelnya sendiri, dan masing-masing punya model yang sesuai dengan karakteristik dari ketatanegaraan mereka. Sama halnya di Indonesia, kami juga punya ketatanegaraan, dan pemerintah dalam hal ini juga mengusulkan untuk melakukan pembentukan badan ini sesuai dengan ketatanegaraan kita. Jadi kalau kita lihat di Indonesia punya cabang kekuasaan itu ada 3, eksekutif, legislatif, dan yudikatif. Itu kita harus tetapkan dulu. Ini menjadi cabang yang mana? Ini yang sedang didiskusikan dengan DPR. Tapi apapun nantinya yang akan diputuskan, prinsip-prinsip terhadap badan ini memang perlu diterapkan. Ada 4 prinsip yang kita perlu terapkan. Adalah pertama tentang standar karena saya tidak bisa lihat presentasinya dengan jelas, saya buka dari HP saya, maaf. Jadi pertama terkait dengan struktur institusionalnya. Standar strukturnya harus independen. Ini prinsip dasarnya. Apa artinya? Bahwa DPA ini tidak di dalam pengendalian siapapun. Dia harus dapat otoritasnya dari undang-undang. Walaupun kalau nanti ditetapkan atau kemungkinan besar adalah ini di bawah eksekutif. Apapun itu, tapi otoritasnya itu sudah ditetapkan oleh undang-undang. Selain daripada strukturnya, dia juga harus fungsionalnya. Jadi strukturnya independen, fungsionalnya pun harus independen. Nah, ini yang nanti yang kita harapkan dibahas juga, apa saja ya yang membuat badan ini atau otoritas ini bisa independen yang diamanatkan oleh undang-undang. Yang berikutnya, yang ketiga adalah secara administrasi juga independen. Dan juga nanti struktur personalnya, SDM-nya juga harus independen. Itulah yang sebenarnya prinsipnya. Jadi jangan mempertentangkan apakah ini bentuknya kuasi pemerintah atau anti pemerintah, tapi lebih kita harusnya membahas tentang bagaimana sih badan ini dalam menjalankan fungsinya sesuai dengan amanat undang-undang. Berikutnya adalah terkait dengan kenapa kita butuhkan undang-undang atau rancangan undang-undang perlindungan data pribadi di Indonesia. Ini adalah bagian daripada amanat undang-undang dasar kita, sesuai dari yang diamanatkan undang-undang dasar itu ada di artikel 28G, itu di mana bagian daripada hak asasi dari masyarakat yang perlu dilindungi. Dan di situ juga bahwa memberikan amanat kepada pemerintah untuk memastikan hak-hak asasi masyarakatnya terjamin. Ini adalah yang kenapa kita mengusulkan. Saat ini sebenarnya kalau kita lihat Undang-Undang Sanksita juga ini adalah selaras dengan artikel 71 of Human Rights Law yang the government to be responsible to the protection and enforcement of human rights. Jadi kenapa ini kita usulkan sebagai cabang kekuasaan eksekutif? Karena memang ada aturannya yang menyatakan itu di Undang-Undang tentang hak asasi. Itu menjadi bagian. Selanjutnya kalau kita lihat bagaimana sih sekarang ini? Bagaimana sekarang ini pemerintah menjalankan fungsinya dalam memastikan pelindungan data pribadi ini bisa berjalan dengan baik. Jadi kalau kita lihat sebenarnya saat ini Indonesia memiliki lebih dari 30 regulasi yang mengatur tentang pelindungan data pribadi. Nah inilah menjadi terlalu banyak bagi masyarakat untuk mana referensinya dan juga memang belum sekomprehensif yang kita harapkan. Kenapa kita perlu? Jadi yang sekarang ini operasi pemerintah atau menjalankan fungsi pemerintah itu adalah berdasarkan dengan undang-undang yang ada saat ini. Dan untuk Kominfo sebagai pengampunya yang saat ini kita mengacu pada Undang-Undang ITE dan Peraturan Pemerintah Nomor 71 dan juga ada Peraturan Menterinya sebagai petunjuk teknisnya. Apa saja yang dilakukan mamanya? Sekarang ini adalah sebagai supervision, melakukan supervision. Kalau ada breach itu kita melakukan investigasi. Saat ini kita sudah menangani lebih dari 32. Belum yang terakhir yang kita baru saja dengar juga di media-media, ini juga langsung kita lakukan investigasi. Yang kedua adalah kita melakukan koordinasi karena ini pasti tergantung sektornya. Kalau itu sektor keuangan pasti kita melibatkan sektor keuangan. Waktu itu juga ada kita menangani bersama dengan pemerintahan DPA-nya di Malaysia waktu itu. Ya kita ada kaitannya dengan perhubungan, ya kita juga mengontak perhubungan untuk memastikan bahwa data-data orang Indonesia ini dilakukan proteksi. Kalaupun saya bocor, bagaimana memitigasinya, bagaimana menekan risikonya. Kita juga melakukan mediasi antara antara pelaku. Selain daripada itu, kita juga punya tim law enforcement-nya. Kita di Kominfo itu khususnya di tempat Direktorat Jenderal Aplikasi Informatika itu memiliki yang namanya PPNS itu penyelidik pegawai negeri sipil. Jadi dia sama punya fungsi dan wewenang seperti polisi yang diamanatkan oleh undang-undang. Nah ini yang kita lakukan. Nah yang paling penting yang kita lakukan juga adalah edukasi. Edukasi kepada masyarakat, edukasi kepada perusahaan, kita melakukan sosialisasi, bekerja sama ini untuk memperkenalkan sambil juga kita menyiapkan, menuntaskan pembahasan RUU Pelindungan Data Pribadi. Ini diharapkan kami masih punya optimisme bahwa RUU ini akan diselesaikan tahun ini, karena memang kalau ditunda-tunda ini akan menjadi yang rugi ada masyarakat. Masyarakat tidak punya panduan yang baku, yang komprehensif bagaimana melakukan pelindungan data pribadi di Indonesia. Ini harapan kita juga akan dibahas segera mungkin. Ini sudah diagendakan, kita menunggu pengagendaan untuk pembahasannya. Nah, kedepannya bagaimana sih organisasi ini? Organisasi juga memang kita juga mendapat masukan dari masyarakat, kita juga ingin memperbaiki bagaimana ke depannya. Saat ini memang sekarang di Kominfo dan saat ini belum komprehensif, jadi kita kalau kita menangani kasus-kasus itu maksimum kita hanya memberikan rekomendasi, belum bisa melakukan sanksi administrasi berupa denda umpamanya, supaya memberikan kejerahan bagi para data controller dalam menangani atau mengelola data-data pribadi ada dalam kekuasaannya. Nah ini dengan adanya undang-undang ini nanti kita bisa membuat suatu tindakan yang bisa membuat efek jerah, paling tidak mereka akan meningkatkan proses perlindungan data pribadi dalam penguasaannya. Nah, kedepannya kami juga punya harapan akan merubah, akan kita memberikan dapat masukan, tapi opsi-opsinya memang tidak banyak karena sekali lagi pemerintah tidak akan lagi yang namanya membuat kuasi-kuasi lembaga-lembaga kuasi. Kalau memang ini menjadi tanggung jawabnya eksekutif, ya eksekutif yang bertanggung jawab, eksekutif yang harus membuat badannya dan menetapkan. Nah, kewenangannya kita harapkan ada di undang-undang. Nah, opsi-opsinya apa saja sih? Opsinya ada, contoh-contohnya ada banyak. Kita punya yang namanya non-ministerial government institution. Ada yang langsung bertanggung jawab pada presiden, ada juga bertanggung jawab pada presiden, tapi melalui. Contohnya BSSN itu bertanggung jawab pada presiden, tapi melalui Kemenko Polhukam. Kalau BP POM itu adalah badan juga dibentuk oleh presiden, Perpres bentukannya. Dia bertanggung jawab pada presiden melalui Menteri Kesehatan dan seterusnya. Jadi ada yang langsung itu yang langsung juga ada, saya cuma lupa badannya. Tapi ini kira-kira yang kita ingin propose nantinya kalau kita membahas ini dengan DPR, karena ini opsi-opsi yang ada. Tapi yang penting ada tadi, apapun nanti badannya, yang penting adalah tugas dan wewenangnya dan bagaimana badan ini dijalankan harus ada dimuat di undang-undang. Itulah menjadi panduannya. Itulah jadi pegangannya dalam menjalankan fungsi dan tugasnya. Nah, saya harap sih semua stakeholder di Indonesia mari saling mendukung untuk menyelesaikan. Jadi mari kita membahas ke substansinya. Kalau tentang kelembagaan ini sudah baku karena ini ada ketatanegaraan kita. Mari kita bicara dengan tentang substansinya, apa yang perlu dimasukkan di situ. Karena kita sangat membutuhkan yang namanya undang-undang ini karena aktivitas masyarakat Indonesia saat ini makin meningkat. Aktivitasnya di ruang digital. Dan kita semua tahu setiap kali kita beraktivitas di ruang digital, kita dimintain data pribadinya. Untuk itu kita perlu suatu payung hukum memastikan data-data pribadi masyarakat yang dikumpulkan digunakan sesuai dengan peruntukannya dan tidak meminta melebihi yang dibutuhkan. Dan pada saat sudah terkumpulkan harus diproses sesuai dengan ketentuan dan juga diwajibkan untuk menjaga keamanannya. Itu kira-kira yang saya rasa dalam diskusi kita ke depannya harusnya mengarah ke sana supaya kita bisa menuntaskan segera RUU ini, termasuk stakeholder yang ada yang terlibat dalam pembahasan pembahasan RUU ini. Karena kan dalam pembahasan sistem di Indonesia terbuka dan setiap orang bisa memberikan masukannya. Itu harapannya. Semoga RUU ini segera dituntaskan dan bisa juga selesai tahun ini dan kita punya pegangan karena masih ada waktu pada saat kita diundangkan itu masih ada waktu untuk adjustment. Seperti kita lihat tahu kan di GDPR itu ada adjustmentnya 2 tahun. Nah, ini kita kan harus ada adjustmentnya berapa tahun itu nanti juga akan dibahas di dalam pembahasan kita dengan parlemen. Itu kira-kira yang saya bisa update terkait pembahasan RUU atau persiapan RUU kita. Semoga informasi ini berguna buat kita semua. Terima kasih.
Thank you, Pak Semi, for updating us with some processes that are currently existing in Indonesia. Pak Semi has also given us a little bit more about Indonesia's pathway to regulate personal data in Indonesia. I actually have also 2 follow-up questions regarding your presentations. The first question is that Prof. Munir has mentioned before that data breach notification is highly important. I want to know how do your ministry see the existing regulations in responding to data breach cases in Indonesia, and how is the role of data protection bill in addressing the data breach cases in Indonesia? In the sense that what kind of what level of action that Indonesian government will be taking to address this data breach issue. That is the first question. The second question is because you've mentioned about the institutions and having the fact that it seems the government more likely to choose a different path of establishing the data protection agency that is quite different, I think, from what has been growing in Europe and what has been existing in some countries in Asia like Japan and South Korea, where the agency is fully independent, not under any executive institution. How do you see this will impact our relationship to other countries such as European countries and also private sectors when it comes to matter that we believe that data exchange is trans boundaries, and there is the demand from most countries to have data protection agency in their partnering countries to be fully independent in terms of institutionally, not only functionally. I think those are the questions that I need to be followed up by Pak Semi.
Thank you, terima kasih Pak Fadli. Jadi kata pertama dalam penanganan yang sekarang ya, di penanganan yang sekarang benar ya. Jadi memang kalau kita lihat peraturan yang sekarang ada itu inadequate, jadi memang kurang. Karena sanksi terberat adalah kita memberi teguran keras dan mereka melaksanakan rekomendasi kami hasil investigasi. Jadi mereka nanti habis itu kita datang lagi untuk audit, memastikan yang kita rekomendasikan sudah dilaksanakan. Itu seberat-beratnya saat ini yang bisa kita lakukan karena belum ada payung hukumnya. Tapi di Undang-Undang ITE pun sebenarnya membuka bahwa masyarakat bisa melakukan legal action kalau mereka merasa dirugikan dan dapat membuktikannya di pengadilan. Nah itu yang harapan kita agar setelah kita punya undang-undang yang komprehensif, menjadi pedoman bagi semuanya. Pertama adalah deklaratif terhadap hak-hak subjek data, kedua adalah kewajiban-kewajiban bagi para pengendali data, bersama juga dengan data prosesornya, dan juga memberikan kewenangan dan batasan-batasan apa saja yang bisa dilakukan oleh data protection agensinya ini atau DPA-nya ini. Itu yang jadi harapannya itu, di mana juga di situ dalam ada juga pedoman-pedoman bagaimana sih menangani kalau ada kegiatannya kriminal, itu ada undang-undangnya juga dalam pasal-pasal itu. Jadi kita memang membutuhkan pedoman ini supaya lebih komprehensif. Nah terkait kelembagaan kita lihat banyak sekali tiap-tiap negara memang punyai yang namanya konsep sendiri-sendiri. Tapi mari kita bicara yang diharapkan adalah independensi. Bagaimana independensi dibuat? Kan tiap-tiap negara punya aturannya. Contohnya Uruguay di dalam di kekuasaannya tetap di cabang eksekutif. Tapi dia juga bisa dapat comply namanya, atau Israel di bawah Kementerian Kehakiman. Itu bisa. Jadi bukan dari mananya lembaga ini atau siapa yang membentuknya atau siapa yang melaksanakan. Bagaimana aturannya yang menegaskan dudonnya terhadap lembaga ini, kewenangannya apa. Jadi kalau ada pertanyaan juga sih, bagaimana pemerintah akan mengadili pemerintah? Kenapa kita nggak bertanya bagaimana polisi mengadili polisi yang bersalah? Kan bukan karena polisinya, karena ada undang-undang yang mewajibkan. Nah inilah independensi itu harusnya di situ, bukan pelaksananya. Karena yang dilihat adalah undang-undangnya, apa yang diamanatkan oleh undang-undangnya. Itu yang diperlukan. Kalau lembaga kan tiap-tiap negara punya ketatanegaraan, apa kita harus mengikutin. Kalau kita lihat bilang Eropa parlementer. Parlemen boleh menunjuk badan, silakan. Tapi di Indonesia kita hanya mengakui 3. Konstitusi kita mengakui adalah 3 cabang. Kalau tidak malahan tidak ada sustainability-nya di mana kalau tidak ada di dalam 3 ini. Itulah kenapa kita kalau memang ini menjadi kewenangan pemerintah ya pemerintah yang membentuk. Toh pemerintah sekarang ini juga bisa diawasin oleh parlemen. Dan pemerintah juga tidak imun terhadap gugatan. Elsam juga pernah menggugat pemerintah, nggak apa-apa. Itu memang itu bisa karena kita sudah negara demokrasi. Check and balance-nya sudah ada. Kalau kita membuat satu lagi lembaga di luar di luar cabang-cabang kekuasaan ini, malah tidak akan sustain di Indonesia. Tidak akan sustain ke depannya. Itu kenapa dan juga amanat dari Undang-Undang HAM, karena itu pelindungan data pribadi ini ada bagian daripada HAM sesuai dengan Undang-Undang Dasar kita, dan di undang-undang itu juga di deklarasi artikel 71 pemerintah bertanggung jawab. Loh, pemerintah bertanggung jawab tapi mereka nggak bisa ngapa-ngapain, bagaimana? Kalau memang mau dibuat siapa, tapi jangan dibilang pemerintah bertanggung jawab. Siapa yang bertanggung jawab? Agar mereka bisa menjalankan tugasnya. Dan sekali lagi pemerintah itu tidak imun terhadap gugatan. Kalau memang ada kesalahan bisa dipanggil oleh DPR. Kalau ini terkait layanan publik, ombudsman bisa masuk juga. Kalau ini terkait kebijakan yang tidak sesuai dengan undang-undang, bisa diajukan di PT UN. Jadi check and balance-nya sudah ada. Jadi kita nggak perlu meniru juga plek-plekan dengan negara lain. Bagi Eropa, yang penting bisa dalam pelaksanaan tugasnya mereka independence. Itu kira-kira jawaban saya. Terima kasih.
Thank you, Pak Sebi, for your explanation. I believe that some of the participants have more questions about these institutionalizations of the data protections regulations in Indonesia, but I will let participants to ask you more at the end of these discussions. I think I will move to Dr. Ivy Patju to...
Or maybe you also participant can write the question and I will answer, because I have another 10 minutes I have to move to other session. So apologize for that, but the question can be sent through the panitia. Jadi biar nanti saya jawab.
Yeah, thank you, Pak Semi. Move on to Dr. Ivy Patju. Dr. Ivy will present her thoughts on how the Philippines deal with some hurdles in developing its personal data protection law and what lesson learned that we can take to speed up the process of the human rights mainstreaming in Asian countries. To Dr. Ivy, the screen is yours.
Okay, magandang hapon sa lahat. Good afternoon, everyone. On behalf of the Foundation for Media Alternatives and our director, Lisa Garcia, I thank you all for inviting us to this panel. So I've been fortunate to have worked with both civil society and government in the Philippines, and I've actually been part of the development of the standards in data protection in the Philippines. So our law is called the Data Privacy Act. It was enacted in 2012. It is widely known that this law came to be because of the lobbying of the business process outsourcing sector, the BPOs, then and now remain to be considered a sunshine industry in the Philippines, contributing significantly to the Philippine economy. Now, even if this appears to be the main lobbying force in the enactment of the law, we should not forget that this law is not just economic legislation intended to encourage foreign investments or support a particular sector. Even if we look at how the National Privacy Commission has implemented it, it has implemented it as a human rights legislation. It is a law primarily intended to protect individuals through the protection of their personal information. And I think on this part, the NPC has been consistent also because there is a strong involvement of civil society throughout the development of the data protection regime in the Philippines. My experience, as I've mentioned, has been both for the government. Even before I became involved in the National Privacy Commission, I was already working with the Foundation for Media Alternatives. So, and afterwards, I'm back with FMA. So even before there was a Data Privacy Act, civil society was already active, advocating for data privacy in the Philippines. Now, if we look at how this law has eventually been implemented, in the National Privacy Commission, I would want to point out the panel and the audience to, I think, three important features. Number one, the NPC, the National Privacy Commission, has always valued stakeholder engagement. Number two, the implementation of the law has been centered on the data subject and respect for the rights of the data subject. And number three, NPC in its implementation of its implementing rules, in implementing the law in general, has acknowledged the importance of the work that has already been done and the developments in other jurisdictions. So NPC actually was a bit late in terms of being operational. The law was enacted in 2012, more than almost a decade too. But the first officials were only appointed in 2016. While this law was lobbied by the BPO sector, the appointment of the officials, part of those who pushed the first officials of the commission were appointed, were the civil sector. In fact, I became involved in NPC because of the recommendations of civil society. So that was the beginning. You know that the civil society was already strongly advocating for privacy. And during the difficult times at the start of the commission in 2016, during the first few years, they were appointed, but they had only 3 officials, the 3 officials of the commission. They had no permanent office, and their budget was not released. So with limited resources and a lot of challenges already, it was at the time that one of the major government breaches happened in the Philippines. If you are familiar with the Commissions on Elections data breach, that was in 2016, just a few days after the first commissioners were appointed. But stakeholder engagement was already very important with the NPC. So when they built or developed the foundational rules, the implementing rules of the law, stakeholder engagement was part of the plan. So it wasn't just making a law, but they engaged stakeholders by having public consultations. So can you imagine how a commission with no office and no budget was able to go, and not just in the main national capital region, but also go to the Visayas and the Mindanao regions, the other islands of the 7,100 plus islands of the Philippines. So they were able to do this, and a big part of this was because of the support of civil society. So civil society supported both in terms of logistics and manpower support so that these public consultations could be held. Now, this general approach of involving stakeholders was continued throughout the years under the leadership of the chairman of NPC, Chairman Liboro. So they have afterwards established the Data Privacy Council. This is a council made up of representatives from the different sectors, whether it's the health sector, the BPO sector, real estate, industry, media. So they have a Data Privacy Council regularly consulted, giving feedback and recommendations to the National Privacy Commission. So in terms of implementation, I think the fact that NPC acknowledged early on the importance of working with stakeholders helped shape the direction of the implementation of data privacy standards in the Philippines. The second one is being centered on data subject rights. Actually, a lot of the first people working in NPC, a lot of them came from civil society. The OIC director of policy in NPC was also from FMA. The chief of the complaints was also from another NGO. So you can imagine that as the foundation of NPC was being built, there was a lot of inputs from civil society. There were also members of the academe. So that was the mix at the beginning. And so when you look at NPC issuances, there is a conscious effort to be mindful of the rights of data subjects. That is why the priority during the first years was education and empowerment of the data subjects, and later on, data subject rights became one of the issuances in NPC. Now, the third one is NPC acknowledging already what has been done. So at the onset, the law is already influenced by both APEC data privacy principles at that time and the EU Data Protection Directive. But at the time that the law in the Philippines was being enacted, debates were also already ongoing for the General Data Protection Regulation. So when you look at the final outcome of the Data Privacy Act in the Philippines, it has incorporated in advance a lot of the things that were introduced in the GDPR. So in the Philippines, for instance, the DPA enacted in 2012 already mentions data portability. The DPA in the Philippines already has mandatory data breach notification. So in the Philippines also, they looked at other jurisdictions in terms of developing the compliance and accountability framework by looking at the privacy management programs developed by other jurisdictions. So I think the Philippines is one of the first countries who required the designation of a data protection officer. It's part of the law that there is an accountable officer. And there are no exceptions. No? Unlike GDPR here, if you're processing personal information, then you have to have a DPO. As you know, the DPA is also a very comprehensive law. It applies to both government and private sector. It even has provisions that allow for extraterritorial application. But the Commission also asserts its independence as an agency because its decisions are reviewable only by the judiciary, so judicial review. So this is the general approach of the NPC, and the framework is risk-based. So you will see the Commission advocating for privacy impact assessments for high-risk data processing. So as against this framework, of course, the 5 years into the NPC's implementation of the Data Privacy Act, the challenges remain. As I've mentioned earlier, for instance, they have had cases. There's no problem in the programs of the NPC. They have advocated for public education. In requiring a DPO, they have also established a DPO training program that is founded on accountability, compliance, and ethics. Now, the challenge probably is in enforcement. If you look, we had the first case in NPC in 2016, the breach of the Commission on Elections database, which compromised millions of data of Filipinos. In 2019 to 2020, NPC experienced thousands of cases filed by thousands of data subjects because of online lending applications. And now during the pandemic, there were calls in the Philippines saying maybe the Data Privacy Act should be suspended, as amidst a lot of complaints on related to phishing, other scams. So these are the challenges that NPC faces. The manpower of NPC has remained the same. So you can imagine how this served as limitation. So if I were to look into the challenges, then this is probably because of enforcement. There is a need to have more manpower. There may be need for investments in digital transformation. If you look at other jurisdictions, how to reach the more than 100 million Filipinos with 120 manpower, perhaps the answer is really digital transformation. And of course, since it's almost a decade, law reform is something to look into. We need to account for the changing times. We need to strengthen the enforcement powers of NPC. So far, these cases filed against NPC have resulted mainly in compliance orders. Whether it's a breach notified to the Commission, they would ask the personal information controller to do certain things to ensure that they're complying with the Data Privacy Act. And because they are centered on the data subject, a lot of these compliance orders go into how they can assist the data subjects who have been, whose data has been compromised as a result of the breach. They have also decisions that result in stop processing orders. Just recently, I think the Commission has asked Google to take down certain applications related to online lending because of the possibility of violating data protection principles. So stop processing order, I think, is one of the stronger enforcement measure that the NPC is able to do, but only very few has been issued. NPC also had, on occasion, awarded damages to data subject and recommended certain cases for criminal prosecution. What we are waiting for from NPC is the implementation of administrative fines. To date, 5 years later, this has not been fully operationalized yet. Perhaps NPC is studying and now currently asking for comments on their rules on administrative fines. So the road towards establishing a data privacy culture is long, and this has become more evident during the pandemic. But things that we should look into moving forward is how to strengthen the regulation and look into empowering individuals. NPC conducted a survey, and surprisingly, in that survey earlier on, I think 2017, a lot of people that were interviewed claimed that their data privacy rights were important to them, that they wanted to know what their rights were as a data subject. But the question really is, even if these privacy rights appear to be important, how are they being translated to actual practice? So actual empowerment of individuals so that they themselves can actually protect their data privacy. So we have people saying data privacy is important to us, but have we equipped them on how? Do they still just share their information without thinking of the consequence or without realizing its value? Of course, the civil society remain to be important partners of NPC. Foundation for Media Alternatives, for instance, has continuously through the years provided informational materials on data privacy. Right now, they have a free course on data privacy. But I think the more important role of civil society and how they have influenced the development of data privacy standards in the Philippines is because they serve not just to complement NPC, but also to challenge them, to make sure that the voices of the people, not just the loud majority, but maybe even more so, the silent few who need the protection the most are heard. So they can amplify these voices and serve to ensure that at the center of this data protection regime in the Philippines, human rights is at the center. So that is all for our inputs into the Philippine development of the data privacy standards. Thank you. Salamat.
Thank you, Dr. Ivy, for giving us some, insightful knowledge about how is it going on in the Philippines. One question for Dr. Ivy is that regarding the NPC, based on what you were saying previously, that NPC is quite multi-stakeholder and in a way independent. How did this idea of independency come up at the first place when developing the law, or is there any challenges that you experienced when this idea of independency coming up when the process of developing the data privacy laws in Philippines takes place?
Two things in the Philippines that would be important for establishing independence. One is already provided in law. It's supposed to be an independent body. It's attached to an executive branch, but under Philippine laws, if you say attached, it's only for policy coordination. So the measure of independence for the NPC is how the decisions of NPC will be handled. In the Philippines, it is by judicial review, and we have had some cases already brought before the courts. So you cannot appeal to an executive department to change the decision of the National Privacy Commission. So by law, that is the standard. Now, of course, the second part is in actual practice. So the leaders of the National Privacy Commission have to continuously ensure that they are able to protect their independence. So I think those are the two things to look into to ensure that the Commission remain as an independent body. This is important because our law covers both government and private institutions. So they have to monitor the compliance of government agencies as well. As we know, perhaps the biggest collector of data is government. So the Data Privacy Act of the Philippines is a whole chapter just to mandate the security of information being processed by government agencies. That is it. Thank you.
Thank you, Dr. Ivy. We will now move on to Ariane to see how private sectors have contributed in developing a privacy policy platform, especially in Asian regions, and what is the tech industry's perspective to strengthen the right of data subjects, including its safeguard mechanisms and other important issues around data protections. To Ariane, the screen is yours.
Thank you so much, and thank you to the organizers for allowing Facebook to share our perspectives and our views on the topics just mentioned by our moderator. So let me start off by saying that Facebook has been advocating for a globally harmonized framework for effective privacy and data protection. And similar to other members of the private sector, both within the tech sector and outside of that sector, we've been very actively engaged in consultations across the region, especially now as various Southeast Asian countries have been drafting their first-generation data protection laws, including Indonesia. We also have Vietnam currently in that process, or amending existing data protection legislation, such as Singapore. They just concluded that process earlier this year, and the Philippines is undergoing that process as well. We've also been partnering with various educational institutions, trade associations, civil society organizations, and think tanks in building, hosting, and supporting various multi-stakeholder fora on discussing and providing feedback on various data protection legislation and regulation proposals. As many of us in this forum or in this event may know, the venue for consultation when it comes to active data protection or any piece of legislation and regulation, we can actually benefit from having more of these discussions. And that is why Facebook is very supportive of having more of these fora, more of these discussions. And that's what we've been doing across the Asia-Pacific region, working with external stakeholders in setting up these forums for various discussion. And one of these is called actually the Privacy Dialogues, and we've been having several of these in different Southeast Asian countries. In addition to supporting these fora for discussion, which I hope other members of the private sector will similarly do, in Singapore and in other countries, for example, in Latin America and in Europe, we've been working with regulators to organize regulatory sandboxes and policy prototyping programs to examine various aspects of privacy laws. For instance, our work in Singapore with the Infocom Media Development Authority, it involves examining and, in fact, re-examining notice, consent, and transparency frameworks and artificial intelligence explainability and transparency frameworks through these regulatory sandbox programs and through these policy prototyping programs. And the goal of these programs, these innovative regulatory approaches, it's actually to provide tested, practical feedback on how to improve these frameworks. So it's not merely a theoretical exercise, but what we do is work with other companies, work with startups, and work with policymakers to see how we can, in a real environment, improve these either early stage policy proposals or early versions of bills and proposals. Facebook has also been publishing white papers on key topics on data protection legislation, such as transparency and data portability. And you can find these online, and we hope it's something that the audience will find interesting. We've been hosting global conversations on these topics to solicit external feedback, to inform our policy positions and our recommendations, which we provide to policymakers, legislators, and other international organizations. We've openly shared our recommendations on the ideal data protection framework, and I believe some of my fellow panelists here may have even received some of our policy papers, including PACSEMI, for instance, and our peers in industry and some of our civil society friends. For instance, one is that we believe that new privacy regulations should build on the protections similar to what GDPR provides. For example, privacy laws should protect your right to choose how your information is used, while enabling companies to use information for safety and innovation purposes. And another position we've taken is that privacy laws should not require data to be stored locally. And this is something of a trend that we're seeing, data localization proposals, which I hope members of the audience would also be monitoring closely. Because we believe that data localization mandates, this could actually make it more vulnerable. This could make data more vulnerable to unwarranted access. And another feature of an ideal data protection framework or law, which I would go into a bit more detail later, is that it should hold companies accountable when we make mistakes, and that does happen. A common global framework, which Facebook and other members of industry have been advocating for, will ensure that the internet does not get fractured. And it will also ensure that entrepreneurs, especially small and medium businesses, they can build products that serve everyone globally, and that everyone should have the same protections regardless of where they live. So this is one key benefit of a globally harmonized or interoperable data protection framework. But we recognize, however, that as lawmakers adopt new privacy regulations, we also hope that they can help answer some of the questions that GDPR leaves open. We have to note that GDPR is only 3 years old. It's not a perfect instrument, and it definitely does deserve to be re-examined and also see how we can improve upon it. For example, we need clear rules on when information can be used to serve the public interest, clear guidance on the various legal bases for processing data, such as legitimate interests, and how these laws should apply to new technologies, such as artificial intelligence, augmented reality, and virtual reality. And these are definitely interesting questions that both industry, the academe, civil society, and policymakers can re-examine to see how we can further improve these new privacy laws and legislations and regulations that are in the middle of development. Regulation should also guarantee the principle of data portability, and this is something that Facebook strongly advocates for. We believe that if a person shares data with one service, you should also be able to move it to another service. This gives people choice, and this enables developers to innovate and compete. Our professor, my fellow panelist, alluded to data portability regulations in other countries in the Southeast Asian region. That's a very exciting development that we're excited to see and monitor, depending on how it would flourish and how specific regulations would look like on this topic of data portability. One country to watch out for would be Singapore. As earlier mentioned, Singapore recently just had a data portability right included in its framework, and we are waiting for the first set of regulations, and we expect that to come out early next year. Now, I'll discuss some ideal aspects of ideal data protection legislation based on the examples we've seen from across the Asia-Pacific region and across the globe. For us, for Facebook and other members of industry, ideal data protection laws are focused around 3 core areas. First is that people should have rights over their information. Of course, these should be rights that they can expect to be honored by anyone who holds it, and meaningful recourse in the event that their rights are not honored. The second core idea is that organizations that hold people's data should be subject to obligations to handle that data responsibly. And I'll provide a few examples on that later on, including this concept that we call accountability. And third, this is something that has been discussed quite a lot in this event so far this afternoon. These obligations should be enforced by a single, dynamic, and innovative regulator that has robust enforcement powers, embraces innovative regulatory models, is consultative and is open to various stakeholders, and is empowered to provide recourse for consumer complaints. And more importantly, as a member of industry, this regulator should also enforce privacy rules in an effective, consistent, and predictable way. And then, in addition to these 3 core ideas, strong and effective data protection legislation should embody the following principles. One is that the law should ensure meaningful, so this would not be inflexible or formulaic protections and compliance obligations. So when we say meaningful, we mean to say that the law adopts a risk-based approach, and Dr. Ivy mentioned this a while ago. Risk-based approach, meaning it's focused on the right outcomes instead of mere check-the-box compliance obligations. Another characteristic, and this is very important, of course, for all tech companies, is that a privacy law, it should anticipate the future, meaning they are technology neutral and they are future-proof. So this means they are efforts or principles-based. Instead of specifying quite strictly, technical standards, for example, having just one or two or having a prescribed list of, for example, de-identification techniques or privacy-enhancing technologies, because having these strict specifications upfront in a piece of legislation, that would make the law quite quickly outdated. So we would advocate for being technology neutral and future-proof on this point. Any privacy law should also likewise enable innovation and, more importantly, facilitate participation in the global digital economy by individuals and businesses of all sizes, by enabling the free and cross-border flow of data in a privacy, protective, and secure manner. Another characteristic or another principle of an ideal data protection framework is that the framework or the law is broadly applicable, but it's scalable to entities of all sizes. It also prioritizes responsible data practices over blanket consent requirements, because in our view, existing consent frameworks in various pieces of legislation all over the world can be improved and modernized at this point. And it should also incentivize privacy protective practices. And this would be de-identification techniques, for instance, data minimization, and incentivizing and encouraging the use of privacy-enhancing technology. And now, please allow me to go into a bit more detail on the three core ideas I mentioned. So the first one I'll tackle would be that legislation should give people rights over their information, again, regardless of who holds it, subject, of course, to specified reasonable limitations. So these rights, these would include the rights to, for example, know who holds data about people and how that data is being collected, used, and shared. The right to access and correct their information is also a very key element or a very key right to any data subject. Another is the right to bring the data a person provides with them to another service, so the right to data portability, and also to have the right to control how their data is used and shared, taking into account the contextual expectations of every data subject. Another important right to recognize and for obligations to honor would be the right to delete and de-identify personal information and to obtain redress if their data is used for a decision that has a legal or a similarly significant effect on them. And in addition, people should be able to seek resolution from a single regulator for complaints about how a company processed their personal information or if a company has not resolved a specific complaint. I mentioned reasonable limitations to these rights. So we also believe, of course, that these data subject rights should be limited in exceptional circumstances. And for example, these exceptions would include if exercising these rights would compromise privacy or security, for example, by requiring the re-identification or the de-identification of data, or providing access to someone else's private content. Another exception would be if exercising these rights would interfere with law enforcement or efforts to guard against malicious or unlawful activity, or if it would compromise an organization's intellectual property rights, or if it would require disproportionate effort taking into consideration available technology. Or, at the bottom line, if exercising these rights would violate other laws or violate the rights of other individuals. The second aspect that I will go into would be that legislation, more importantly, it should require that organizations that hold people's information should adhere to obligations for responsible data handling. and to be able to demonstrate this compliance with these obligations. And this concept is commonly known in industry as accountability. So to be more specific on our recommendations around these obligations, for instance, obligations of organizations should include requirements on transparency. Obligations should, of course, be clear about how we collect and how we use personal information. They should also be required to have comprehensive privacy and security programs appropriate to their size. So the program should be designed to assess and mitigate privacy and security risks, and it should also ensure that privacy is built into every product and service. So this is related to the concept of privacy by design. Another requirement would be on accountability. So organizations should be able to demonstrate compliance and even certify that their privacy systems and controls are working. Another obligation would be on data minimization. Obligations should only collect and maintain personal information for permissible purposes and otherwise delete or aggregate or de-identify personal information. And another obligation, which a previous speaker already mentioned, would be on breach notification. Obligations around providing breach notification on organizations so that they would notify people of data breaches most likely to harm them, according to a pragmatic breach notification standard. And the third one, which I'm quite excited to go into because there's been a lot of talk on this afternoon, we go to the characteristics of an ideal data protection regulator. We believe that an effective privacy law should be governed by a single regulator, empowered to enforce the law in a way that's predictable, that's consistent, and that's technology neutral. So these are characteristics that members of the tech industry would be quite appreciative of. This regulator should also provide clear guidance, again, to organizations about what is expected of them, especially when you're dealing with a privacy law that's quite new. Having clear guidance from a regulator that's focused on educating stakeholders is very, very important. And in addition, the regulator should be expected to implement innovative regulatory tools if it's within its capacity, such as policy prototyping programs or regulatory sandboxes. So these are approaches that promote cooperation with organizations, that promote innovation and new methods of oversight. The regulator should also be empowered to seek broad input. So we are very much appreciative of regulators that take a consultative approach to policymaking, to issue clear rules around procedural and substantive matters, and of course, to also interpret the law, and as I mentioned, give guidance to organizations. And I think one other characteristic that members of industry would really appreciate, and this is an example that we've already been seeing across the region, is for a regulator to provide regular and transparent reporting on their cases and on their decisions, because this will help consumers and organizations understand what practices are expected or what's prohibited. It's an ideal way to provide guidance to its stakeholders. So for Facebook, we see that countries that are developing first-generation comprehensive data protection laws, such as Indonesia, they now have the unique opportunity to embrace demonstrated best practices, such as those that I've mentioned a while ago, and to learn from the successes and the challenges of other countries, especially neighboring countries within the Southeast Asian region. Countries that are now drafting their laws can improve upon existing models and leave behind outdated models, which are already quite inadequate and have to be modernized to address the needs of a data-driven world. So we encourage other members of the private sector, and we hope to continue engaging with policymakers, members of civil society in Indonesia and in Southeast Asia, as we all undertake the effort of contributing towards the process of drafting and updating our country's personal data protection laws. Thanks again for the privilege of sharing Facebook's views this afternoon, and we look forward to having similar opportunities in the future.
Thank you, Ariane, for sharing your thoughts on these issues. And it is also important thing that you've mentioned about the three core ideas. And I I actually want to know about how to implement those core ideas into different settings across the Asian regions. But because we're running out of time, I think I will move on to Mas Wahyudi to present about the dynamics of the development of the Asian data protection standards. I will give the last 10 until 15 minutes of presentations to you, Mas Wahyudi. The screen is yours.
Thank you, Fadli, for this time, and good morning, everyone. Good afternoon, everyone. All the distinguished participants and speakers of the first Southeast Asia Internet Governance Forum. First of all, I would like to thank all the committee for the opportunity to contribute in this discussion. I hope everyone are well amid the difficult situation due to COVID-19 pandemic as a global virus. And so in this opportunity, I will try to make reflection of the process of developing of the personal data protection law in Southeast Asia, starting from the existing concept of privacy and the development in each country and the region. The right to privacy is new concept in Southeast Asian country as reflected from the minimum guarantee of the recognition of the right to privacy protection within the constitution of each Southeast Asian countries. From 11 Southeast Asian countries, it's only Philippines, Indonesia, Cambodia, Myanmar, and Timor-Leste, of which constitution explicitly regulate the protection of the right to privacy and the private life. Indeed, the constitution are relatively new as the presented after the 2000. Indonesia conducted the amendment of the constitution, adopted the Bill of Rights as the second amendment on 2000, and the Timor-Leste establishing the constitution on 2002, and Myanmar and Cambodia conducted of the amendment of constitution on 2008, which mostly adopted the privacy concept regulated in several human rights treaties. It's only Philippines, which possibly has the longer historical root through in Constitution 1987, and emphasize more on the privacy aspect of the communication, which refers more on the Fourth Amendment of the American Constitution. In general, it can be said that the privacy conceptualization in Southeast Asia, as reflected in the constitution of the several countries, it emphasizes more on the protection aspect of human dignity, as emphasized by European countries, reflected by the developing of the modernized Convention 108, and also in the last of the General Data Protection Regulation. Thirdly, are some which emphasize more on the protection aspect of reputation and honor to the people, as the Philippines and Timor-Leste constitutions, which are closer to the U.S. concept with more strengthen the respect and the reputation of the people. It must admitted that so far the Southeast Asian countries have not been able to conceptualize the privacy, which draws together between the need to protect individual interests and the communalistic society's characteristic, as they depicted by Alan Westin on the concept of the Indonesian community privacy, departing from the study conducted by Clifford Geertz in Indonesia to the model of the family home and the ritual ceremony, the community of Java and Bali. The birth of the ASEAN Human Rights Declaration in 2011, in the paragraph 21, specifically grant the guarantee of the protection of the right to privacy and the private life, which basically refers more on the universal concept of the right to privacy as formulated in various human rights treaties. It means that it is still hard to find the same perspective and starting point in Southeast Asian countries regarding the privacy conception and the development of the legislation's instrument, including the development of personal data protection law. It can be seen from the development of the several data protection law in the ASEAN countries, including the process of the formulation of ASEAN Personal Data Protection Framework in 2016, as mentioned by Professor Abu Bakar Munir, of which the material and speakers pinpointed more on the aspect of economic objective, apart from the privacy conception as the fundamental rights, as affirmed by the ASEAN Human Rights Declaration. It is different from the EU GDPR and also modernized Convention 108, which specifically have the objective to protect of the fundamental rights, not specifically mention the objective to what is the economic objective as one of the pillars of the formulation of the regulation and the convention. The unclear situation of the development orientation of the personal data protection law in Southeast Asian countries can also be seen from the different orientation of personal data protection legislation of Southeast Asian countries which have each developed. Malaysia enacted the personal data protection in 2010, and Singapore in 2012, for example, in which the law explicitly specifies that the formulation of such law aims at economic objective. Similarly, it is also when we read Law Electronic Data Protection Law on 2017 and Thailand Data Protection Act 2019. It's only Philippines Data Privacy Act 2012, of which objective of law aims at protecting the right to privacy as the fundamental rights. Meanwhile, the several countries which are currently in the process of the deliberation of the personal data protection bill, such as Indonesia and Vietnam, the discussion about the economic aspect is thicker. Third, in the consideration of Indonesian Personal Data Protection Bill, explicitly specifies the objective of the Personal Data Protection Bill, establishing such legislation to protect the fundamental rights of the citizen, as mentioned by Pak Semi in previous presentation. Because the formulation of Indonesian Personal Data Protection Bill, it is referred to the Article 28G, paragraph 1 of Indonesian Constitution as one of the part of the Indonesian Bill of Rights as a result of the second amendment of the Constitution. The different orientation in the development of data protection law has implicated on the various material and standard adopted by each data protection regulation in ASEAN. ASEAN Personal Data Protection Framework 2016, for example, mostly adopted the Hong Kong Personal Data Protection Ordinance, specifically on the aspect of protection principle in personal data processing. Meanwhile, the ASEAN countries, which become the pioneer of the birth of personal data protection law, namely Malaysia, Singapore, and Philippines, mostly adopted the EU Directive 46 1995 on data protection from the European Union, through not all objectives aimed at protecting fundamental rights like the EU directive. So the different objective between the models refers to EU Directive 46 1995, refers to the modernized Convention 108, but the content and the materials of the legislation in Malaysia or Singapore, the objective to specifically mention about the economic aspect. However, the countries lately initiated the legislation of the personal data protection, such as Thailand, Indonesia, and Vietnam, have the legislation material refer to the EU General Data Protection Regulation. Thoroughly, they have several differences. For instance, related to the proposal of establishing the Independent Personal Data Protection Authority, explained by Pak Semi, between the difference of the proposal from the government and the response from the Indonesian House of Representatives about the model and the format and the structure of the Data Protection Authority in the Indonesian Data Protection Law. Such situation, in my opinion, makes it difficult for the evolution process and development of regional data protection standard in Southeast Asia, as we have not agreed the basic things such as the conception of the privacy itself and the objective of the personal data protection law. However, we then are forced to rapidly catch up with the data protection law development due to the rapid data technology innovation. Today, we have not finished the conceptual and the basic framework on personal data protection, but we have to immediately prepare the ASEAN Data Management Framework mentioned by Professor Munir and the model of contractual clauses for cross-border data flows in ASEAN as the agreement of the ASEAN Digital Ministries in January 2021, which has established the working group on digital data governance and chaired by the Singaporean government. As a result, there are several basic differences in the personal data protection legislation variants of the Southeast Asian countries, which have impacts of the effectiveness in implementing the legislation of personal data protection, specifically in the context of protection to fundamental rights. The differences, for example, relate to the scope of material of the data protection law of Malaysia and Singapore, which only legally bind to the private sector, while Philippines and Indonesia apply to both private and public sectors. Such a difference then implicates to the model of personal data protection authority, whether it will be the part of the government or be established as independent institution with a multi-stakeholders composition. Mine will, according to Professor Graham Greenleaf, the existence of the Independent Data Protection Authority will much determine the effectiveness in implementing the data protection law in the countries. On the other hand, the biggest challenge for Southeast Asian countries related to the aspect of legal ground of the processing, the data processing principle, the protection of the right of data subject, and the obligation of data controller and data processor. So, with the available current development and departing from the achievement of Southeast Asian countries in development of data protection legislation, as well as several basics problem above, the ASEAN countries' government should have been able to promote the existence of the working group with a larger and more comprehensive working area in my perspective, of which the works involve the multi-stakeholders. This working group can start the initial process of evolution development of personal data protection standard in the region with the clarity of conception, the objective, and devices required in the data protection law. Such standard can be referenced for Southeast Asian countries, as well as in the indicator instrument is determining the personal data protection law equality or personal data protection adequacy of the South Asian countries and beyond. So I think it is my presentation for the introduction of the session. This reflection are what can follow and the introduction, and we will discuss more detail in the session of question and answer. Thank you, Fadli.
Thank you, Mas Wahyudi. It is actually there is a lot of things to take in these discussions, and because we are running out of time, I actually want to jump into specific questions to Arian regarding the different level of data protection implementation that is existing in Asian countries. You've mentioned about 3 core ideas that is implemented by Facebook, and also previously you have mentioned that Facebook has been taking a different approach to different setting across the Asian region. my question is, what is the lesson learned that other sectors, especially the government across the Asians, can take from tech industry to reconcile the different understanding of how to balance between human rights standards to the needs to catching up with digital transformations that needs to open more innovations and fundamental protection at the same time? I think regarding the different level of understanding and implementation among countries, I would also want to know perspective from Professor Munir. I think I will let Arian to speak first, and then Prof. Munir.
Sure thing. I'll kick that off. Thank you so much. So you did mention respecting privacy rights as a human right, and also recognizing the need for supporting innovation, especially for Facebook. We believe that respecting human rights, especially privacy rights, and encouraging innovation, these are not mutually exclusive. In fact, they're very complementary, and these can be accomplished both by private organizations and also by government. So I guess a couple of ideas on that would be from the private sector side. It's really looking at what your company's values are and having a set of privacy principles that you will uphold and that you will respect. And our privacy principles, these are publicly available online. And I also invite people and the audience right here to look those up. So that would be like the privacy principles by which Facebook operates. And this would also take into consideration, of course, balancing innovation with respecting human rights, especially the right to privacy. And again, the reason why I keep on going back to these principles is because having a set of principles by which your company will I guess, look at their standards, will abide by, will observe in their operations, this would really provide top-level guidance on what is allowable and what is not allowable. Having a set of principles will really guide organizations both at a departmental level and on an individual level. And it's a good reminder for various members, whether these are employees or leaders of the company. This would provide a good level of understanding as to expectations and setting the parameters, especially when it comes to upholding the privacy rights of your users, of people who are using your service, and balancing that against your goals for innovation and technological development. So the key takeaway there would be really for organizations to have a set of privacy principles that they are expected to uphold and that they expect their employees to uphold. Now, on the flip side of that would be on the government side or on the policymaker side. We believe, of course, that, again, data protection and data innovation, these could go hand in hand. A good model that I would like to cite would be Singapore's Personal Data Protection Commission. So that would be under the Infocom Media Development Authority. So interestingly enough, the regulator there, the privacy regulator, they hold two hats, or they hold two roles or responsibilities, and they view data innovation and data protection as the same, as the two sides of the same coin. And this is also a good benchmark, I guess, or a good standard for other policymakers and other regulators as they're setting up their data protection offices or data protection authorities. Because having that dual mandate of protecting data and of driving innovation, I think it's a good principle, or it's a good way to think about spurring technological development and economic development, and at the same time making sure that interests of data subjects and of people are protected. I'll pass it on to, I guess, the next speaker who will be addressing the same concern.
Much for the questions. I got 2 points to make here. One is the fact that ASEAN is a very diverse region with 650 million people spread out across 10 countries and at different level of development. I think enforcing a one-size-fits-all framework would be very, very challenging. But at least I think a basic parameters of the legal framework can be agreed upon. And of course, as I mentioned just now, ASEAN framework on personal data protection is a good starting point. Some basic parameters are there. So perhaps it can be used as a guidance for ASEAN economies to develop their personal data protection law. But we have to take into account other principles like, apart from, as mentioned by Avian just now, about the principle of technology neutrality is very, very important. We cannot have a legislation specifying a specific technology in the legislation or in the framework, because you should be able to basically, we should allow technologies to develop, and it can be artificial intelligence, it can be biometric, it can be other technologies. So a principle of technology neutrality is very important. But at the same time, I think we have to take into account international benchmarking as well. International benchmarking is very, very crucial. And the third element is that a domestic requirement. Yeah. So there are three principles or three factors to be taken into account: principle of technology neutrality, international benchmarking, and domestic requirement or national requirements. Right?
Okay, thank you, Prof. Munir. Mas Wahyudi, do you have a takeaways in responding these issues regarding the different level of understanding across the ASEAN?
Yeah, I think we can start from the ASEAN framework on the personal data protection, as mentioned by Professor Munir, and also encourage the pillars of the ASEAN community with the several pillars, including the economic aspect, political aspect, and also the society aspect, because ASEAN also developing the ASEAN Human Rights Intergovernmental Commission, ICHOR, as one of the pillars of the ASEAN community. So the several pillars of the ASEAN community can take a seat and discuss about the models of the privacy, refers to paragraph 21 of the ASEAN Human Rights Declaration in the one side, and another side, I think consideration the economic aspect with the big market of the innovation of the information technology in the ASEAN region, especially with the several decacon, etc. So based on the development, we can discuss the model of the standards, but in the levels of the basics and the roots of the privacy and the personal data protection legislation before we discuss about the indicator of the standard contractual clauses, etc. Because currently, I think just Singapore, Malaysia, and the Philippines have the strong and the indicator to conduct of the cross-border data flows. Even Indonesian government currently also still in the progress to develop of the model of the cross-border data flow with trust before the G20 meeting next year, because in the next year of the G20 meeting, Indonesia as the presidency of the G20, and Indonesia have the interest to develop of the model of the cross-border data flows to continuing the proposal in the previous of the G20 meeting in Tokyo. Yeah, I think from our side.
Thank you, Mas Wahyudi. I think before we wrap up the discussion, I want Dr. Ivy to respond to the last questions regarding the scammers issues. Do you think that the subject's request for their scammers identify should be disclosed? Yes, that's the question.
Oh, yes. In the Philippines, actually, there have been decisions of the commission that go into whether a person may have a right to request information from a controller when he or she has been a victim of irregular transactions. And the commission in that case said that the personal information controller should cooperate. that as part of the rights of the data subject has a right to know who the recipient of his or her personal information is. So in this regard, I think the Commission is saying that if there are reasons and justifiable reasons, and that if it can be exercised as part of the rights of data subject, then controllers who have access to these kinds of data should provide this information. Of course, because of the strong requirements under the Data Privacy Act, this will likely be decided on a case-to-case basis depending on the situation. So my opinion is the same as the opinion of the National Privacy Commission on this.
Thank you, Dr. Ivy. As we have to end this discussion, I want to ask all the speakers to give some closing remarks around maximum 2 minutes, especially give a comment on what's critical issues that we have now on the table to address in speeding up the legislation process and to speed up our efforts in mainstreaming human rights standards, especially within the Asian regions. I will give the opportunity first to Mas Wahyudi Jafar, and then to Prof. Munir, and then Arian, and the last one is Ivy.
Yeah, I think this is the era for the Southeast Asian countries to more discussing about the privacy and the data protection with the social and historical context, because we have the situation about we have the difficult situation to conceptualize of the privacy, the model of the protection of the private life in the past in several considerations. So based on the development of the technological information, especially currently we can discuss more detail and more contextual with the needed of the ASEAN peoples to develop of the model of the privacy law and the data protection law, and also try to balancing the economic aspect, economic objective with the obligation the ASEAN countries, ASEAN government to protection of the right to privacy as a part of the fundamental rights. Thank you.
Prof. Munir, please.
One sort of sharing of news from Brunei. I've just read a report on public consultation issued by the authority in Brunei on data protection order, they call it, for the private sector. So in Brunei now, they don't have legal framework or regulations in relations to private sector. They have issued a consultation paper in May. So I think this is an interesting development for us to follow through. And the second thing I would like to suggest here perhaps is, for ASEAN to seriously consider to revisit ASEAN framework on personal data protection, and perhaps to modernize it, because if you look at the other international instruments or international or regional instruments like Convention 108, it has been modernized, it has been revised. OECD Guidelines 1980 has been revised, as we know, in 2013. And then European or EU directive has been replaced with GDPR or EU GDPR. I think it's a high time for ASEAN to seriously consider revisiting the personal data protection framework and try to modernize and upgrade the provisions perhaps, because as it is now, the principles are very loose, and as I mentioned, it is not binding, it is a voluntary instrument. So 2 points as a last remark on my part. Thank you.
Please, Arian, you can go.
Thank you. So as a few parting words, I have 5 quick points. Number 1 is to encourage fellow members of the private sector and also the attendees here, especially those in civil society and in other sectors, to really participate in these consultation processes that are happening across the Asia-Pacific region right now. Sometimes it does take a bit of effort to really follow the developments, to see which consultation processes are open, but it is worth it to make sure that your sector is well represented and is able to really provide the input and the feedback that matters to your sector. And that is greatly appreciated by the people who are drafting these pieces of legislation. Another reminder would be to really support the free flows of data across borders with privacy and security safeguards in mind. The threat of data localization is really looming in our region. We're seeing this development already in South Asia, and we're hoping that Southeast Asia would instead take the course of really supporting what Prime Minister Abe of Japan has called as the data free flows with trust. Transferring data across borders is possible with privacy and security in mind, and we hope that this is the standard that other policymakers in Southeast Asia would follow. The third recommendation or the third reminder I would have right now is really for policymakers to take a risk-based approach to make sure that the policies and the laws they're currently drafting are tailored and are responsive to specific and concrete harms, and not just pushing for a check-the-box compliance obligations. The fourth one would be to ensure that in developing various privacy laws, frameworks, and regulations, they're not created in a vacuum. We have to make sure that there are no conflicts with existing laws. And this is also a shout out, I guess, to policymakers and legislators who are also thinking about other data-related legislation, such as those targeting artificial intelligence, augmented reality, virtual reality, content regulations, and advertising laws. So just to make sure that there's harmonization and that there are no unintended consequences of coming up with conflicting laws. And the last one, I guess, again, coming from the private sector, is to make sure that in the development of these proposed privacy laws, regulations, and amendments, that we all be informed by technical and business realities and take pragmatism to heart when we're developing these laws. And that would all the more be assured by taking a consultative approach in drafting these proposals. And again, thank you for allowing Facebook to share our views. Thank you to the organizers for this event this afternoon.
Thank you, Arian. Dr. Ivy, please, your last remarks.
Okay, I'd just like to say that we all know that we are experiencing the fourth industrial revolution, and there are things we cannot deny. Number one, the world is connected. Number two, there is much more to expect from the combined power of information and technology. And number three, protection of individuals transcend political or territorial boundaries. So there's no better time to work together than now. We support initiatives to establish regional standards, drawing strengths from our similarities while accommodating our differences. In moving forward to establish regional standards, I think that it will be challenging, and we should not attempt to try to unify our laws right away. We should aim for instead universally acceptable principles like the ASEAN general principles. This means for me in practice that we continue to allow for derogations per country, but we focus on areas where mutual cooperation will be most beneficial, such as information sharing, cooperation on enforcement, and focusing on the mechanisms for the cross-border transfer of data. What's important is that as we face the challenges of this era, we are always mindful that progress should be built on the respect of fundamental rights, for it to be effective, to be sustainable, and to be empowering. Thank you. Salamat.
Thank you, Dr. Ivy. I think that becomes our wrap-up for today's discussions. I believe that there is a lot of exchange knowledge, and I hope you learn as much as I did from these discussions. I would like to thank again to all the speakers for sharing with us, and to all those participating in this discussion. I would also like to thank to the CIGF 2021's committee for organizing this session. I sincerely hope that you're staying healthy amidst these current situations. Thank you and have a nice day. Bye.
Thank you.
Thank you. Bye.
Terima kasih. Thank you.
Thank you, everyone.
Bye.
Thank you.